Why should lawyers study economics? Why should economists study law? The economic analysis of law unites two great fields and facilitates understanding of each of them. You probably think of laws as promoting justice. Indeed, many people can think in no other way. Economics conceives of laws as incentives for changing behavior, implicit prices, and as instruments for policy objectives, efficiency and distribution. However, economic analysis often takes for granted such legal institutions as property and contract, which dramatically affect the economy. Thus, differences in laws cause capital markets to be organized differently in Japan, Germany, and the United States. Failures in financial laws and contracting contributed to the banking collapse of 2008 in the United States and the subsequent recession, which was less severe in Japan and Germany. Also, the absence of secure property and reliable contracts paralyzes the economies of some poor nations. Improving the effectiveness of law in poor countries is important to their economic development. Law needs economics to understand its behavioral consequences, and economics needs law to understand the underpinnings of markets. Economists and lawyers can also learn techniques from each other. From economists, a lawyer can learn quantitative reasoning for making theories and doing empirical research. From lawyers, economists can learn to persuade ordinary people. An art that lawyers continually practice and refine. Lawyers can describe facts and give them names with moral resonance, whereas economists are obtuse to language too often. If economists will listen to what the law has to teach them, they will find their models being drawn closer to what people really care about. The plan of this book: to benefit from each other, lawyers must learn some economics and economists must learn some law. Readers can do so in the next two chapters. Chapter 2 briefly reviews macroeconomic theory. If you are familiar with that theory, then you can read the material quickly as a review or skim the headings for unfamiliar topics. As a check, you might try the problems at the end of Chapter 2. Chapter 3 is an introduction to the law and the legal process, which is essential reading for those without legal training. We explain how the legal system works, how the U.S. legal system differs from the rest of the world, and what counts as law. Chapter 4 begins the substantive treatment of the law from an economic viewpoint. The chapters on substantive legal issues are arranged in pairs. Chapters 4 and 5 focus on property law, chapters 6 and 7 on tort law, chapters 8 and 9 on contract law, chapters 10 and 11 on resolving legal disputes, and 12 and 13 on criminal law. The first chapter of each pair explains the basic economic analysis of that area of law. And the second chapter applies the core economic theory to a series of topics. So chapter 6 develops an economic theory of tort liability, and chapter 7 applies it to automobile accidents, medical practice, and defective products. Chapters 4 through 11 deal with laws where the typical plaintiff in a suit is a private person, private law. And chapters 12 and 13 deal with criminal law where the plaintiff is the public prosecutor, public law.